Good morning. I'm Sean Tuma, and I want to tell you about a recent case out of the Fourth Circuit Court of Appeals that has created quite a bit of stir lately. This case involved a decision by the court that held that travelers had to cover a data breach claim brought by the claimant under a commercial general liability policy. And what has created quite a bit of stir out of this is the fact that over the years we've seen a growing industry of cyber insurance that's designed specifically to cover cyber claims, because the prevailing view has been that commercial general liability policies do not cover such claims. So the question that now arises is, what does this do to the cyber insurance market? How does this impact it? And my answer is, based on reading the opinion, not a whole lot. This really doesn't impact it a whole lot. And the reason for that is because you have to look really carefully at the nature of the breach involved in this case. And when you do, you see that it's fairly atypical and not something that we would see under these types of policies going forward. The facts of this case are instructive on how the court reached its opinion. The plaintiffs in this case discovered their healthcare information by doing a Google search for their name. When they did this Google search, they were able to find this information because Portal Healthcare had put it on their server in a manner that was not secured and provided completely open access to the public. So by simply searching for their information on the internet, they were able to pull it up and find it. And so obviously they made a claim, and then Portal Healthcare submitted its claim to Travelers for coverage, and Travelers sought a declaratory judgment that held they were not required to cover this claim. What's important here is Portal brought its claim under coverage Part B of the policy, which dealt with advertising injury. Now, advertising injury under the policy covered the electronic publication of material that discloses information about a person's private life. As I said, this information was discovered by the plaintiffs when they did a simple Google search and found their private information open to the public. What the court found in this case was that when Portal Healthcare put this information on the internet in a manner that was open to the public, that was a publication of that information, and therefore it was covered under the advertising aspect of the policy. Now, when thinking about data breaches, most data breaches aren't a result of a company openly publishing information out on the internet. Usually it's a result of something more, someone accessing information improperly, taking some unlawful act, or it's lost or theft, but it's in a limited manner such that it's not open to the public. And the court mentioned that this information was open to the public view on the internet for anyone in the world to see. So it is important, and that distinguishes this case, in my opinion, from a couple of other cases that courts have found there was no coverage. For example, a New York court found that Sony was not entitled to coverage after hackers accessed its database and exposed information out to the public. The court found that it was not a publication by Sony when the hackers did their malicious act and exposed the information versus Sony doing something that puts it out there. Similarly, in a New York case, there were 130 tapes containing private information that were lost. And the court found that also was very different than the facts of this case, because by having tapes being lost and only presumably one person finding them, and then having that information exposed to one or maybe a few people, as opposed to being on the internet and posted for the entire world to see, the court found that was different as well. And so in those cases, the courts found there were no coverage. In this case, the court found there was coverage. So going forward, my view of this case is that based upon the discrete nature of the facts at issue, we're not going to see a major impact on the cyber insurance industry, and we're not going to see the floodgates open for courts to start finding coverage for data breaches under commercial general liability policies. One reason for that is, in this case, the policy was several years old. So it was a dated policy that lacked some of the exclusion language that we're going to see in most current commercial general liability policies. So this is something you need to look for in your own policies. The second reason is, and this is what I discussed earlier, most data breach cases where companies are seeking coverage do not involve a publication in the sense of how the court found a publication in this case, such as by putting it on the internet without any protections or any precautions for getting to it. In most cases, it's going to involve either a loss that's going to be covered by one or two people, maybe a few more, or it's going to cover malicious actors where the courts find that that's not an action by the company, therefore it's not a publication.